Now, as I mentioned before, I submitted 3 briefs, to the Supreme Court on behalf of JPFO. 2 of them were in important cases, Heller and McDonald. The first one I actually submitted was in a case called Silvera versus Lockyer. Not a particularly important case. The case actually didn't make it to the Supreme Court. Just a quick understanding of how this stuff works. It's great to be a Supreme Court judge because you don't have to hear any case you don't want to hear. The way it works is they get to pick the cases that they want to hear, they throw out all the cases they don't want to hear, and they really decide what their own docket is going to look like. So what you have to do is you have to ask permission. You have to ask them to take a case, and what you file is a petition for certiorari. And if they grant your petition, it means they're going to hear the case. And that's how all these cases work. So back in 2003, there was a challenge to California's assault weapon ban, and it was making its way up through the federal courts. And the district court, the first court, heard the case and dismissed it because they said it was the Second Amendment was a collective right. It then went up to the Court of Appeals, called the Court of Appeals for the Ninth Circuit. The Court of Appeals for the Ninth Circuit said, no, it's a collective right, dismissed. And so JPFO asked me to lead a group of attorneys. I was the lead counsel, and we prepared a brief in connection with that plaintiff wanted to seek a review by the Supreme Court. And so what JPFO did was they put in a brief called what's called an amicus curiae brief, a friend of the court. And just so you understand how that works, Supreme Court cases and appellate cases always affect more people than just the parties in the case. You go to trial in a regular lawsuit, and it's me versus him, and he owes me money, and I sue him, and at the end of the day, either he owes me money or he doesn't. And it really doesn't affect anybody else. But when you're at the Supreme Court, the decision that the Supreme Court makes affects everybody. Although I may win and I may get my money, they're going to announce some sort of large legal principle that's going to govern all the rest of the cases. And so everybody wants to have something to say in that case. So they have what's called the Friends of the Court. And a friend of the court, an amicus curiae, gets to put in a written argument. They're not a party to the case, but they get to put in a written argument, and they give their perspective on the case. And they say to the judges, look, these guys I know, they have a dispute. But I also have something to say about this because the decision you make is going to affect me too. Now, in the Heller case, there were 66 amicus briefs. I think it was 40-something on the Heller side and 20-some odd briefs on the District of Columbia's side. It's a lot of briefs. By the way, that's not the record. I think that's like 3rd place or something like that. I think the record is 100 or something crazy like that. But that's a lot of reading to do. I think in the McDonald case, it was 40-some odd amicus briefs. So we submitted an amicus brief not on the merits of the case, but on the application for the court to take the case. And the court declined the case. And it sort of, Silvera went into the dustbin of history as a case that the Supreme Court didn't hear, and you move on from there. But what was really important about that case is not what the Supreme Court did, and not what the court did at the Court of Appeals for the Ninth Circuit, but what the dissenting judges did. When a panel of judges makes a decision, they don't all necessarily agree. And the majority judges win, and you have judges that rule the other, or would like to rule the other way, and they can write an opinion as to why they disagree with the majority opinion, and that's called a dissenting opinion. In Silvera versus Lockyer on the Ninth Circuit, there were 2 judges that wrote really, really great dissenting opinions. One was Judge Kleinfeld, and he wrote a very, very scholarly, very learned, very well thought out, historically based, legally based opinion. It's actually very good reading if you're interested in that kind of stuff. And that's really the better opinion. But the more interesting opinion was an opinion written by Judge Alex Kaczynski. And it was very short, but it was very quotable. And in his dissenting opinion in Silvera, he wrote a paragraph. He wrote a paragraph that it sent chills up my spine at the time, and it still does. And I put it in both of my amicus briefs. I want to read it to you because it illustrates something I think that's very important. Kaczynski wrote, in dissenting in Silvera, he said, "The Second Amendment is a doomsday provision, one designed for those exceptionally rare circumstances where all other rights have failed, where the government refuses to stand for re-election and silences those who protest, where courts have lost the courage to oppose or can find no one to enforce their decrees. However improbable these contingencies seem today, facing them unprepared is a mistake a free people get to make only once." Now, that's what you need on the bench to move the ball forward and get this. You need judges like that. You need judges who understand what it's about. I mean, this judge understands exactly what the Second Amendment was written for, why it's there, why the framers thought we had a right to keep and bear arms and why it was important to protect. And it turns out we actually have a lot of these judges today. We have at least 5 of them on the Supreme Court of the United States. We have at least a few of them at the Court of Appeals for the Ninth Circuit. And the more judges you have like that, like Judge Kaczynski, who understand this stuff and realize the importance and realize the significance of enforcing these kinds of rights, the easier it is to actually vindicate those rights in court and make sure that they're protected. And that's, that's absolutely critical. And that's a very, very essential thing that we have. Now, what's happening today? Because obviously, it doesn't stop here. It starts here. Heller and McDonald is the beginning. And I know that Bob alluded to one of the cases. Right here in New Jersey, we've got 2 things going on already. Right now I'm handling the one gun a month challenge to the challenge to the one gun a month law on behalf of ANJRPC. That's my case. We have the challenge to justifiable need, the carry law. That's the Mueller versus Manza case, which is an SAF case. Although ANJRPC is one of the plaintiffs, and actually I'm involved behind the scenes in that case. ANJRPC has me working with the lead counsel to move that case along. And both of those cases are now back before the court. There is briefing going on right now, and that should be before the court within the next couple of months. What else do we have? We've got California case, a challenge to the California carry law. Peruta versus San Diego, and that's an NRA case being handled by a guy, Chuck Michel, who does a lot of NRA work. There are 3 other carry cases around the country being handled by Alan Gura, one in New York, one in Maryland, one in DC. There's a lot of stuff going on. After the Heller case was decided, what happened? Their handgun ban was struck down, so what did they do? They passed a permit law. And they passed an onerous permit law to prevent people from getting permits or to make it really difficult for them to get permits. So that was immediately challenged. In Chicago, as soon as McDonald came down and Chicago's law was struck down, what did Chicago do? Chicago passed a law. They passed a permit law to make it the same exact way, to make it difficult to get handguns. That was immediately challenged. There's actually a case going on in New York where a guy is actually doing this on his own. He's challenging the residency requirements for a handgun permit. And that just scratches the surface. Those are just sort of the well-known, sort of publicized cases that people know about. But there's other stuff going on, and that stuff is impossible without what has come before. And this is 2011. This is 1 year after McDonald, and I just rattled off 10 cases. That's the beginning. And actually, we're working on a broader challenge to the New Jersey gun control law that we will probably be rolling out sometime this spring. And we'll see that coming. I can't talk about it just yet, but that's in the works as well. So there's an enormous amount of work being done. There's an enormous amount of stuff going on. And it's all because of the energy that people like you and everybody else bring to the process. And I started off the discussion by saying, well, it's exciting to be a New Jersey gun owner. That's very exciting to me. To see this turn into that during my lifetime, and then to see what's going on right now and what's coming, what's to come in the future. When the McDonald case was decided, it just opened up a potential flood of lawsuits that can, push the envelope. And, as I said, it's an incremental thing. The first thing that was attacked was the most basic right, possessing a handgun in your home for self-defense. And to the Supreme Court, at least 5 members of the Supreme Court, that was pretty obvious. And to those same 5 members of the Supreme Court, it was pretty obvious that if it's true for federal law, it's got to be true for state and local law too. Well, now, what do the carry cases do? The carry cases take that exact same concept, and all it does is you walk out your front door. If I have a right to protect myself in my home, why don't I have a right to walk out my front door and protect myself? Well, I don't know. That's a good question. Why not? You ask these questions a little bit at a time, and you get small answers. And that's how it works. And it's, there's kind of a cliche, although I don't really think it's a cliche. It shouldn't be a cliche because it's really true. People say freedom isn't free. This is actually something that I teach my daughter. She's 11. And I try to remind her of this all the time. And that is that free people are always under attack from people who want to take their liberty away. And so as free people, it's our responsibility to be vigilant and do what we can do at all times to remain free. And that's, unfortunately, that's just the nature of being a free individual. You always have to do what you can to remain free. And this process is just one example of it. It's a particular niche, aspect of liberty, but it's a particularly important one. The First Amendment, the Second Amendment, a lot of people consider those sort of the backbone of the Bill of Rights, and I think that's right. I think the First and Second Amendments go hand in hand. And if you want to remain, if it's important to you to remain a free person, and it's important that you remain a free society, it is a relentless, a tenacious, and a constant effort. And I think that's what we're seeing, and I think that's what we're going to see in the future. And again, to see the people in this room, and to see the people that I deal with, and the people, the clients that I represent on the Second Amendment kind of cases, people who say to me, look, don't I have a right to do this? Why do they get to tell me I don't? Or more importantly, how come they can put me in jail if I do that? The answer is, well, you know what? It's an effort. It's a substantial effort, but it's an effort that's worth it, and it's an effort that is so energizing, so exciting, and what I see happening is extraordinary. As I said, I opened this up with this comparison here, and it took actually a lot longer for the civil rights movement to get things going, to go from Plessy versus Ferguson, separate but equal, to Brown versus Board of Education. This is kind of amazing that in 40 years we've done this. And as I said, it's because of this energy in this room and elsewhere. It is very exciting what's happening. And that's why, oddly enough, as I said, even though I never thought I would say it, is extremely exciting to be a gun owner in New Jersey. And this to me is something that we can look forward to, keep it going, and really to stay behind it. Now I know Frank asked me to maybe stay and answer a few questions.
Yeah.
Happy to do that.
Well, first of all, thank you very much. Yeah, I'd like you to, if you could, just take some questions. I have one, if you don't mind.
Sure.
Just starting out. Do you know if anything in New Jersey is if there's any progress being made towards a true castle law?
Well, you mean like on the street, that type of thing?
No, I'm talking about a castle law which would basically stand your ground.
Castle doctrine, there's a little bit of a misnomer. Castle doctrine traditionally refers to the principle of law that in your home you don't need to retreat when confronted with a violent criminal. In some places the law is you do need to retreat, but usually it's the law in most states that you don't need to retreat, and that's the castle doctrine from the idea that your home is your castle. I guess what you're talking about is what some people have been referring to as castle doctrine laws applied outside the home. Is that what you're talking about?
No, I was just talking about, I thought in New Jersey that the rule was that you do have a responsibility to retreat.
I don't believe so. I'd have to look at it, but my recollection of New Jersey law is I think that it does have a castle. We do have the castle doctrine for home. It's something we could look that up, but I think that's one of the good things that New Jersey has. But there are places that actually don't have that, which is kind of strange. But at least it's some kind of recognition of the right to self-defense.